Welcome to Workplace Wake Up, your go-to podcast for practical employment law guidance. I'm Jennifer Shaw, the founder of Shaw Law Group, and I'm here to help HR professionals and leaders navigate the legal minefields of the modern workplace. Each week, we tackle real-world issues with clear advice and a little tough love. Let's get started. We actually have some listeners who are in a different hemisphere, believe it or not, so you all are enjoying winter, I think, at this point. But for those of us in Sacramento, California, it is an absolutely beautiful day. It is not hot yet. I will say that I am dreading the 110-degree weather, which we know is coming at some point. But for now, I'm just going to enjoy this beautiful spring day. So we are going to talk about the Fair Chance Act in California. Now, the first thing I want to say about the Fair Chance Act, because I don't want to forget this, there is a page on the Civil Rights Department website that is dedicated exclusively to the Fair Chance Act. And remember that the Fair Chance Act is a rule that dictates what employers can do with an applicant's criminal history, how you can decide whether or not you should take into account the criminal history, and when you can do that. Okay, there are very strict requirements in California on this issue, all right? So first thing I want you to get is there is that web page on the CRD's website, which is very useful, has a lot of great FAQs and information about the Fair Chance Act. The first thing to understand about the Fair Chance Act is that it draws a very important distinction between an arrest and a conviction. We can be arrested for lots of things that we didn't do, or that the DA doesn't think they should charge for, or just things that can be dismissed, right? I was arrested one time at a rally at my college during the South Africa divestiture. This tells you how old I am. And I don't even think my mother or my sister know this, and they might be listening. Anyway, I was arrested at UC Santa Barbara, but I was released, okay? So it didn't show up. It's not a conviction. When I applied to be a lawyer, though, I had to disclose that. You have to disclose arrests. It was very interesting. Okay, anyway, bottom line is there's this law, the Fair Chance Act, that makes very clear that, first of all, arrests are off the table in most situations. There are some professions and industries where arrests are important. Like, for example, if somebody's going to be a correctional officer or a police officer, or you're going to have somebody who's getting a classified clearance from the federal government, something like that. But generally, arrests are off the table. It only matters when you've been convicted. The Fair Chance Act is not intuitive, okay? You don't get to just hear it and think, oh yeah, that makes sense. You just don't consider a conviction. Well, when do you not consider it? How do you not consider it? It's very specific, all right? So when you talk about the Fair Chance Act, what I want you to realize is it's not intuitive. It's not the type of thing that you could just guess what the right answer is. And that's really important because I think there are a lot of things that are like that in employment law. It's funny, when I was a brand new lawyer, I was a bond lawyer for a very large international firm. And it was complicated. You had to write these indentures and trust agreements, but it was also so boring. Oh, I could not believe it was torture. So I loved the people I worked with, but I was just bored silly by the work. It was complicated. And yet it was sort of intuitive. Like I sort of got it, okay? I didn't love it, but I got it. Employment law is different. I think people really misunderstand employment law. They think it is this simple, sort of straightforward, intuitive thing. If you know employment law and you've been an HR person for even a few days, you realize it is not intuitive. Far from it, right? There are a lot of rules that just don't make sense. Now, the general sort of public policy on the Fair Chance Act makes a lot of sense to me. Somebody's already been punished by going to jail or being on probation or having to do the sheriff's work project, you know, the people in the vests on the side of the road. They've already been punished. So we don't need to punish them by making it hard for them to get a job. I get that, and I'm on board with it. But there are other components of the law that are hard to comply with and don't always make sense. So when you make a hiring mistake, of course, you can have both reputational risk and legal risk. Hiring and firing are the two most dangerous things we do as employers. So when you think about what you're allowed to take into account when you hire someone, you got to dot your I's and cross your T's. And the criminal history is a very risky place to make a mistake because there are a lot of protections for folks who have already paid their dues to society, whatever they may be, and now they're just trying to make a living. All right? So here's a scenario. Let's say you are recruiting for a position and you make somebody an offer of employment, and it's a conditional offer because as a condition of actually being able to come to work with you, you are going to do a criminal background check, and they're going to have to successfully pass the background check. The background check comes back and it shows a pending charge, okay? It shows a charge that has not been decided yet, right? There's no conviction. And the hiring manager says, wait, a criminal? Hold on, rescind that offer. I do not want this person in my office. I don't want them on my team. And you might feel pressured in HR to move quickly because the hiring manager is an important person in your organization and you don't want to make them unhappy. And you're a little worried about this pending charge too, especially let's make it really hard. Let's say it's for child pornography. Okay, let's make it tough. So you think that's it. We're just going to rescind the offer. We're good. Well, here's the problem. You can't consider non-conviction arrests. So arrests that have happened where there's not a conviction. You can't consider if somebody was sent to a diversion program, which means you would have been sentenced for 3 years. You served 1, and then we put you in pretrial or post-trial diversion, and you're going to be doing a sheriff's work project for 362 days, and then you're going to be done. Okay, that's diversion. Or for whatever reason, the record was sealed or dismissed. It could be that somebody agreed to turn state's evidence and they're in the witness protection program. And so now they have a sealed conviction, or there was some confidential information that can't be released. So the court decided to seal it. Or juvenile records. Juvenile records are never going to be things you can consider. We let kids have a second chance, right? Because they are young when they make a mistake. Now, I know it's, you can make the argument when you're 17 years, 11 months and 28 days old, why is that so much different than being 18? But there has to be a law drawn somewhere, and they draw it at 18, all right? So when does the Fair Chance Act apply? All right, if you have 5 or more employees anywhere, and you have given someone a conditional offer that is based on a background check. Now, it may not just be criminal background. It could be also employment verification, that sort of thing. And it's triggered when you are going to use somebody's conviction history as part of making a determination as to whether they should come on board with you. So remember, nothing happens with the Fair Chance Act if you run the background check and it comes up with nothing. My background check has nothing on it, despite my little incident at UC Santa Barbara. It's clean as a whistle. There's nothing on it. So in my case, if you go to hire me, you're not going to have a Fair Chance Act issue because I don't have any criminal history. It comes up when you have a hit on that criminal history check, whether because you ask them to self-disclose their criminal history, which you can do, or you do an actual background check. So what's the required process if you get a hit, all right, if you get something that shows a conviction? First of all, everything you do in the Fair Chance Act is an individualized assessment. You have to look at each situation individually and independently to decide what you need to do. And the first thing that happens is, let's say I'm a traveling salesperson and the conviction that shows up is felony drunk driving. And you're like, you know what? I don't think this is a good idea for Jen to be in a role that requires so much driving when she's had this felony DUI conviction, let's say 2 years ago, all right? So there are all sorts of factors you go through, and this could take us 2 hours to talk about, so I'm just trying to give you the high points. There are factors you look at, and then if you decide not to hire me, you issue what's called a written preliminary decision notice. So you say, Jen, based on the results of your background check, we are rescinding this offer. We are no longer going to proceed with this offer. Now, that triggers time for me, the candidate, to respond. So I get to say, hey, wait a minute. Did you know that there are 4,781 Jen Shaws in California? And I think you've got the wrong one. I do not have a conviction for DUI. I don't know what you're talking about. And I'll go get my own background check and I'll show you, and then you can show me what you have. And maybe you've got the wrong social security number or the wrong birth date, or somebody screwed something up at the DA's office, but that is not me. So you have to give them the chance to respond. Now, they may respond by saying this is a case of mistaken identity, or they may respond by saying, hey, yeah, that's true. I did have a DUI. But since then, I've gone to AA. I've successfully completed rehab. I haven't had anything happen in the last 2.5 years. And I even have now a very active driver's license. It's been restored. Everything's good. So they can give you what's called mitigating information. Okay, so they can tell you, listen, you're right. I do have this conviction, but here's why you shouldn't hold it against me. All right. And then you look at all of those factors and you can decide whether or not you're going to change your mind. Okay. And if you decide that you're going to go ahead and allow them to come to work with you, then you tell them, okay, the mitigating information you gave me makes sense. And you might even have a last chance agreement, right? You might say, if you are ever considered under the influence of alcohol or drugs while you are in this job, we will drug test you. And depending on the results of that drug or alcohol test, you will be fired. Like, there are things that we can do based on the conviction information we have, and we can still decide that we want to bring them to the workplace. Or you can say, yeah, you know what? Based on this information, you have conviction for child porn, and we're a daycare center, and you're not coming within 100 yards of us. We wish you all the best. All right? So you get to make that decision. Now, you have to do all of this in good faith. So if you just have the view that everybody who went to jail is a bad employee, you got to get over that. All right? Because that's not what we can do here in California. You have to give people a chance to have been rehabilitated. That's required. So what are your practical risk zones when you talk about the Fair Chance Act? First of all, please do not overshare background information internally. You should have one person who's running these background checks who takes it to another person to talk about what needs to be done. You don't want to overshare it. So then you have to look at, how do I document my individualized assessment, right? Make sure that you have some documentation of the factors you looked at, who you talked to. If you talk to anybody, you've got to be able to show that you did that individualized assessment. You cannot have a blanket policy. You cannot say, do not apply if you have a criminal conviction. You cannot do that. You cannot say, we will never accept you if you have a pending charge. Nope. We got to look at it case by case. And remember, an arrest is different than a pending charge. A pending charge is the DA has charged you, but you have not been to trial, or you have not come to a plea deal, okay? And then your other risk zone, of course, is letting the hiring managers make their own sort of off-script decisions about what's going on. You don't even want to involve the hiring managers. You need to know what the job is about, what the risk areas are, and you're going to make the decision. And then when they get assigned to the hiring manager, they don't need to know what was in this person's criminal history, because that can create a bias, right? And then they can be accused of misusing that information. Now, remember something here. There is a reputation overlay to this law, and here's what I mean. If you comply with the Fair Chance Act, you are really driving brand protection, right? You are making sure that you've got the right people coming into your organization. And the other side of that is, if you overreact, you are creating discrimination exposure. If you underreact, there may be a workplace risk. So you've got to find the sweet spot. You've got to make sure you're thinking about your reputation and how to keep your current employees safe, okay? So when we talk about the Fair Chance Act and we talk about criminal history, we are not talking about, can we rescind this offer? That's not the right question to ask. The right question to ask is, have we followed this process correctly, right? Have we gone through the steps? Have we done our individualized assessment? Have we made sure we've evaluated all the factors we want to evaluate? Have we documented that process? And this is a topic that is hot right now. There is some new legislation that has been proposed, AB 2095, which is called the Fair Chance Improvement Act. This bill, if passed, will impose a lot of new legal requirements on employers. So, for example, when you're looking at whether you can do a background check of a current employee when they're accepting a promotion, this law is going to clarify some of that. So keep an eye on AB 2095. Of course, as always, we will update you as time goes on. Also, remember, if you haven't joined Employer's Lawyer or you haven't checked us out, we are actually going to be talking about the Fair Chance Act during our office hours in a couple of weeks. So Employer's Lawyer is a non-traditional law firm. And what we do is we have office hours and we have monthly webinars, and we have Ella, our Employer's Lawyer legal assistant, which is so amazing that you can just type questions into and you get answers. Anyway, all this is on our website. The reason I'm bringing it up is the Fair Chance Act is going to be one of our office hour topics probably next month in April. So if you're interested, go to Employer's Lawyer, check it out. And if you have questions, as always, of course, reach out to me. Also, if you have thoughts about the podcast, you have suggestions, please let me know. Everybody, we are so grateful for this community. And I just love talking to you about these issues and trying to help you stay on the right side of these legal issues. I want to keep you out of court. That is my whole goal in life these days with our clients and with all of our HR friends and family, to keep you out of court. That's the bottom line. So everybody, thank you for joining me. Keep up the good work. You're amazing. Don't forget to take care of yourselves. I get busy and I forget to take care of myself. And I just want to remind you, as a way to remind me, that we need time to exercise and to eat right and to take a deep breath every once in a while, okay? There's a lot going on in the world. There's a lot going on in our personal lives. Work is important, but we can't do work if we're not okay with everything else. So put on your oxygen mask first, okay? Everyone, thank you so much. Have a great rest of your day. I'll see you next time. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. Thank you for joining me on this episode of Workplace Wake Up. If you found today's discussion helpful, be sure to subscribe, leave a review, and share the podcast with your HR and leadership teams. For more insights, training programs, and legal updates, you can visit us at shawlawgroup.com.